An indictment is simply a written charge presented to the district or Supreme Court. So in Queensland, with the more serious criminal charges, what are called indictable offences, although the charges are initially brought in the magistrate's court, once they go through the preliminary hearing in the magistrate's court, what's called the committal proceedings, if the magistrate decides there is a case for the defendant to answer on the charge, the magistrate sends the matter out of the magistrate's court jurisdiction up to the jurisdiction of a higher court, being either the district court or the Supreme Court, depending on how serious or complex the particular charge is. For example, very serious charges such as murder are committed for trial in the highest court of first instance, being the Supreme Court. But once the magistrate commits the matter for trial, then the charge has to be reduced to writing in a document which is called an indictment. And that document, that indictment, has to be presented by the Director of Public Prosecutions to a judge in the higher court, be it the District Court or the Supreme Court, and from that point onwards the matter is dealt with solely in that higher jurisdiction. From the time the magistrate commits the matter for trial, the Director of Public Prosecution has got 6 months in which to present the indictment to the higher court. They can apply for an extension of that time, and in some circumstances the court will grant such an extension, but if there's no extension and the DPP fails to present the indictment in time, the defendant is entitled to be discharged.